I am back with another edition, and this time it is from Elton, your fave, okay, Elton Hart. He gives his analysis, unbiased analysis, sober analysis, if you ask me. And I'm just excited to share this and also break down what I think of his analysis, okay? But before we jump straight into it, this week I did quite a number of videos, but most especially the videos I did on Saturday. I'm just going to say, if you haven't seen them, make sure you hit that replay button, go back, go watch those videos, because I break down a few things which I think are going to be mandatory attendance. Yeah, for your online LLB graduation on these YouTube streets for Tuesday 10 a.m. when the judge comes in and he reads that ruling, because you already know he's going to read that ruling. I break down to you the meaning of R versus Hepworth. I break down the meaning of R versus Lala. And I also break down the meaning of R versus Dun Dun. Okay, I think I covered 3 case laws. And I enjoyed doing that research. So please support those videos. Go right ahead, check them out. Let me know if you learned anything from there. But let's jump straight into Elton Hart, because these are some of the comments you guys said. Elton Hart is the only analyst with a sober mind. He's the best analyst, says another comment. Elton Hart, what a pleasure to listen to this great mind. Elton Hart, you are the best. Elton Hart, you are the best. The only problem here is the judge. Elton Hart, the jack of all trades when it comes to the SENZO MEYIWA trial. So the comments go on and on and on. Listen, Elton, one of the few legal minds when influenced by lies, but following the book. Great Elton, our creme de la creme. There we go. Elton Hart, one of the best analysts. Spot on, Mr. Elton Hart. Salute. And open analyst. On and on and on these comments go, okay? Except one comment. Can you imagine? Only one comment. And this comment says, executive admission by Baloyi is blocking Mapisa from 174. Baloyi is an experienced prosecutor. We do not care, okay? We do not care if he's an experienced prosecutor. At the end of the day, did he put in struggle evidence or not? Yes or yes? Let me know in the comment section down below. He gave a version that he was with a shooter at all times that day. Asilalila, says this commenter. But you already know they responded to them multiple times. Let's jump into this video analysis. Elton Hart, the floor is yours.
Afternoon to the viewers.
Section 174, discharge at the close of the state's case. What are we talking about, and why do you believe it is that Mapisa, of all the 5 accused, is the one pursuing this angle?
If one looks at Section 174 of the Criminal Procedure Act, one needs to now understand the section of the Act very nicely. It doesn't say there's no evidence at all. It makes the distinction between sufficient and insufficient evidence. And Mapisa is saying that there's insufficient evidence that link him to the commission of the crime. Although there is this Zungu chap that said he saw them in Vosloorus on the night. To be in Vosloorus doesn't necessarily mean that he was involved in the crime, in the commission of the crime. But then again, that is now circumstantial evidence that the state has to build its case surrounding that to say cell phone data, the communication between the accused persons, and you try and create that type of link. But when he brings that application, he's not saying there's no evidence that say he was not in Vosloorus at that time when the crime was committed. He's maybe say sufficient evidence to link him that he played a role, direct or indirect, in the commission of the crime, because we heard they were talking about co-conspiracies and those type of things in the arguments.
And there is Elton's first point, which echoes a lot of what we've been saying in the comment section. I've been saying in the videos. So we're on the right track, family. We are on the right track. So let's apply our legal learning here. There isn't enough. There isn't sufficient. There we go. Okay. Baloyi come through. There isn't sufficient evidence to place Mapisa, accused number 4, at the crime scene. He might have been in or around Vosloorus. The tower might have pinned Maluleke Tower, Vosloorus Tower, whichever tower might have been pinning. But are you telling me on those towers, he was the only one on those towers? The 5 accused were the only ones on those towers? It means everybody on that day at the time of unaliving of SENZO MEYIWA and your phone pinged on the tower, it means you're guilty, okay? Especially if you own a hoodie in your closet. So automatically, this is what the state then would have done, right? If we are going by this what is it called? Circumstantial evidence, okay? And now if we're going by circumstantial evidence, then we're going to say male and females whose phones pinged on those towers on that day at that time. Obviously, lucky for us females, we are automatically excluded, okay? Because Uzandi never said the person inside the house was female. We know for a fact the intruders in the house, according to the story of the people inside Pagati the house. We're not going to argue about the validity of the story, but they're saying it was males. So all females whose phones pinged on those towers are automatically eliminated. Now we've got to go with all males that pinged that day. And let me tell you something, that number is not going to be 5. That's the first problem. So therefore, yes, Elton Hart is right. There was not sufficient evidence to say Mapisa is absolutely part of the cause. Let's continue listening on.
So what did he need to do to convince Judge Ratamokgwatleng that I shouldn't even have to respond to what the state has presented, find me guilty at this point after the state closed its case? What was the bar that he needed to meet?
Obviously, remember, an accused person has no onus on him whatsoever to prove that he's innocent. The state has to prove beyond reasonable doubt that he was involved in the commission of the crime. But when we get to the 174 point, the state needs to just say that there's prima facie evidence that suggests that accused number 4 was involved in the commission of the crime. And he has to now come and sort of say, but that suggestion by your evidence, that's not the only inference that can be drawn from that evidence.
Yeah.
There is many other inferences that can be drawn. And once the court can draw different inferences from the same set of evidence, then it means different interpretations can apply to that evidence. Then you give the benefit to the accused person. And he just needed to sort of have, not say beyond reasonable doubt, this evidence can't stand against me, to just say that there's different inferences that can be drawn why I was in Force Lawrence at that stage during that time. Not you can find me at the Kumalo house around that vicinity, looking at the cell phone triangulation and data pinging. Was I at that Kumalo house? And we tried to see, but I think they somehow, when they dealt with the analyst, when they dealt with the cell phone data, they did not do enough for me to actually say that there is other ways that you can also interpret this data.
Okay, we are listening, Elton Hart, and he says there was not enough tackling, okay, of the version of the state by the defense, especially when it came to the cell phone triangulation. So that cell phone triangulation, as you know, Baloyi keeps saying, nope, they pinned on the Mololeki Tower. They pinned on the Force Lawrence Tower. Why didn't they pin on the Force Lawrence West Tower or the Lesedi Tower? They pinned specifically on that one. However, just because you pinned at that tower doesn't mean you were at Kelly Kumalo's house, right? We can all agree on that. So drop a 1 in the comment section. Elton is saying they should have, hammered that point down. Now, in layman's terms, let me explain that a little bit better. So what exactly does prima facie evidence mean? They keep saying prima facie, prima facie, prima facie. We've heard that phrase over and over again, and that's a Latin phrase. And all it means is at first appearance, or your first assumption, or your first perception. So if someone is found in possession of recently stolen goods, that might be prima facie evidence against them, right? So, for example, if you find, somebody with rims, Toyota rims in their hands, and then you know that Mr. Jones's rims were recently stolen from Santon, from his Toyota, and Mr. Dladla here is carrying Toyota rims. The prima facie evidence is, oh my goodness, there are Mr. Jones's rims. But that's not accurate, excuse me for the cough, but that does not mean because he's holding rims that those are Mr. Jones's rims. So therefore, there could be a different inference. Mr. Dladla could have bought the rims on the same day. He could have bought the stolen rims, but it doesn't mean he stole the rims. Do you see what I mean? So basically, if someone is found in possession of recently stolen goods, that might be prima facie evidence that they are guilty of theft. However, they could rebut that presumption because I could have bought the goods, but I didn't know that they were stolen. Let me know if that makes sense. Let's continue because Elton Hart is here to break things down.
Now, obviously, if you go, say, for instance, the DNA, because they look at that cap that was lying at the scene, that they said one of the intruders had the cap on.
That had the sweat or something.
The sweat. Yeah. So they matched it against all 5 accused persons, and that was inconclusive. I'm not saying that there was not markers on that DNA. Yes. That doesn't suggest it could be from one of the 5 accused, but it was inconclusive. Then I said, that's why I said when I look at the cell phone data, the pinging and the cell phone triangulation, they could say most probably that these guys were in a certain triangular. Yeah. But that triangle is so wide, they could have been at some other place. And I could remember that from the evidence that was, in cross-examination, when Advocate Ngome Zulu was still alive, they put to say, but these guys were not really at the hostel, they were at some other place, but in close proximity of that. So what Zungu was saying, it couldn't be that they were all together at the hostel and what Zungu was seeing, according to him. So you could have worked a little bit more with that. And then when we talk about the ballistics, one needs to check, okay, obviously these guys were caught way, like I think in 2020 they were arrested. So it's 6 years. You would not find a lot of ballistics evidence pertaining to gun residue on their hand. So that would be gone. So you need to work with the gun that was found. And for me, I think when, I think it was Mangena that did that testimony pertaining to the ballistics, I think they should have digged a little bit deeper in how they say the bullet trajectories work and also that thing. And even for me, I would have said they had to look at a gun. Can you dismantle a gun and take the what is this now? This I don't have the proper
the chamber. Or
the chamber. There's the word. You're helping me now nicely. The chamber of that, and can place it on another gun and shoot through. And you can you do those type of things? Just you need to create doubt in what the state is presenting. Then the judge has got something to work with.
Listen, I did a whole video on Umzilikazi Where Africa, breaking down his tweets, his chronicles. I don't know how I forgot to include the hat, okay, the infamous hat, the hat that has now resulted in us knowing that there's now a new phrase invented by the state. It's called neutral DNA, okay, because the state continues to struggle. So they have decided English is going to be the hill that they will die on, okay. They are going to just change the English just to confuse the record. But here is the thing, Elton's suit, 10 out of 10, okay? It is absolutely distracting, and I think it aligns very well with his skin tone, but we are not there, okay? I am digressing. Let's get back into what he said. The defense needed to create doubt for the judge to work with. Elton, if you're watching the same case I'm watching, it doesn't matter what kind of doubt you create. The judge is always going, yeah. He's even jumping into the arena. Where is Ngome Zulu to let the judge know he has jumped into the arena? May his soul continue to rest in peace. But the judge this week, he didn't even just dive into the arena. No, he ran the marathon, but then he didn't hand over the baton. And then when he finally handed over the baton, he told Baloyi, listen, you got to come with the Makaleni, okay? I don't know why you're not reusing Makaleni. Makaleni, and then Butelezi Jack. Those are the two hints that the judge dropped, and then he said, Section 186, I am allowed to ask, okay? And then Chigi, it wasn't Kininda who met with Makaleni, because hello, Kininda wasn't there in 2014, the 26th of October, 2014. But we are not there, okay? Elton mentioned something about the ballistics and how the defense could have gone a little bit deep. Listen, Elton Hart. We all watched those days, okay? Those are the days of striations, grooves. There was Sereo. There was Mangena. There was Omnisi who had to go and buy the... Is it? Omnisi had to go to the hardware store. There was also legal aid jumping into the arena again to say, no. The ballistic expert is only hired for accused number 3 and nobody else, because Mr. Ballistic was sitting in court. He was there assisting. So I think it's a little bit, the ballistic thing is beyond this. It's like it's beyond the scope. Like I remember listening from A to Z of all that ballistic stuff. It was quite a lot. At the end of that, I'm definitely a ballistic expert myself now, okay? I now understand how the chambers works, the grooves, the firearms, the striations on the bullets and how the matchings are done. But all that to say, I think the defense did good during the Mangena times in their cross-examination, but I guess Elton Hart is saying they could have done better. They still needed to work even harder to create reasonable doubt in the state's version of things. Remember, Mr. Jones's rims, Toyota rims, were stolen, but Mr. Dladla is carrying the rims. Does it mean Mr. Dladla is carrying Mr. Jones's rims? That, and then all that Mr. Dladla has to do is say, just because Mr. Jones's rims were stolen doesn't mean the ones I'm carrying are his. So let's go ahead, continue listening on. What a breath of fresh air. The question is, will the judge discharge Mapisa? That's the real elephant in the room.
But a big hurdle, though, Elton.
No, a big hurdle.
A big hurdle was the confession of accused number 2, and much of the state's response said, this man confessed and twice confessed in both confessions implicated you, accused number 4, which we've now taken together with other circumstantial evidence. You may be right about the DNA, you may be right about this and that, but taken with other evidence, it gives you a bit of a headache.
But for me, and this is my view, I think on the confessions, now looking at the hindsight of all the evidence that was laid, you can see that, I don't know, I can't recall who was, I think it was Gininda who was the head of transporting these guys up and down. And they, at some stage, at the beginning saying, no, these vehicles were not there, these vehicles were not there. And later they conceded, but these vehicles is there. And that's after the court has made that ruling pertaining to the confessions. So then you need to put one and one together. Before that, you said these vehicles were not there. Now you're saying that something is not adding up. And then does it mean that was these confessions rightfully admitted? And that is for me the prickly pear, and what I think people, because the trial is running so long, they forgot about what Gininda said at the beginning and said later to concede certain vehicles was now suddenly
And
there.
importantly, Elton, please talk to this point very quickly. The confession of one accused not being used against other accused as well, They're relevant to you. You are admitting your role in it. You may implicate others, but...
You can most probably make a confession and say what happened, but obviously co-accused, they can never testify against each other. They can never testify, because then you need to now say, am I not testifying to get a better deal out of the state from the other end? For me, that's the playing ground. And I think maybe if they work better with that confessions to actually revisit that issue. But I think, and this will remain my opinion, I think those confessions were never supposed to be allowed to get in.
All right.
Now that leaves me thinking of Rance in the Jocelyn Smith trial. She didn't have a confession, but she became a Section 204 witness, where she testified against the other 3, and the other 3 got life sentences. So then I asked myself, what is the difference then between a confession where the accused is implicating the others, but that confession cannot be used to convict the others? Woo, Gunigi, right? That's a mouthful. But a Section 204 witness can point at the others and say what exactly happened, and she got away scot-free, by the way. No charges on her, all charges dropped. Very different cases, but pretty interesting. I would have loved to ask Elton the difference between the two. But with that, let me know your thoughts in the comment section down below. I want to hear from you. What is your prediction? Mapisa, Section 174 application discharge. Will he walk? Looking at the evidence and the judge in question. If there was a different judge, what would be your decision? If there was, well, Judge Rata is the ultimate judge here, who is presiding this case. Tuesday morning, he comes to tell us what he has decided. Do you think he's having a fantastic weekend? Let me know your thoughts in the comment section down below. And with that, I'm going to end this video right here. Thank you so much for watching. Remember to like, to comment, to subscribe. Go check out my Mzansi Way Africa video. Yeah, but there's a trigger warning there. So go watch the video. I think that's going to keep us entertained until Tuesday. Thanks for watching. I'll catch you, of course, on my next upload. Bye! I'm Mzansi Unfiltered, checking out. Catch you on my next upload.
My lord, I mean, that's it.
Yeah.
As the court pleases, my lord, I mean, that's it.
Yeah.
If the grooves don't fit, quit the 5 accused. Mzansi has done a fantastic job proving there was no match.